It's an important condition to the issue of an accelerated payment notice, the means by which revenue can get tax up front, in effect, on aggressive tax avoidance schemes, that the scheme has a disclosure of tax avoidance scheme, otherwise known as DOTAS, reference number. So the revenue have not been slow in recognising that the more schemes that have these reference numbers, the more accelerated payment notices they may well be able to issue. So an important step in their campaign against aggressive tax avoidance arrangements has been expanding the hallmarks, basically the tests, for the issuing of DOTAS reference numbers. Now, we've had two new sets of draft regulations to consider. They're out for consideration with responses required by the 9th, 10th of September. And one set, quite important to the financial planning sector, is on the inheritance tax arrangements. Now, the prior consultation indicated that whilst grandfathering would cease, that is, if you had a scheme before these new regulations came in, it wouldn't be sufficient to exclude you from having a DOTAS reference number if you continue to promote that scheme. But all the sound around the issuing of that previous consultation led us to believe that it would be only really aggressive schemes that will be targeted. Well, we have the regulations now, and I think we need a little more clarity on them, because as they are drafted, they don't give us as much certainty as I think we would like. I'm going to quote from them because I think it's quite important. So if we look at these regulations on inheritance tax, forgive the sort of rather tortuous wordings, but that's what you get with regulations. For the purposes of Part 7 of the Finance Act 2004, arrangements are prescribed, that means they're caught by DOTAS, in relation to inheritance tax if an informed observer, that's the important first thing that we need some clarification on. It's an objective test, but what is the test of an informed observer? What sort of qualifications should they have? What would they have been doing? Having studied the arrangements and having regard to all the relevant circumstances, could reasonably, another element of objectivity, be expected to conclude that A, condition 1 is met, and B, either condition 2 or condition 3 is met. So what is condition 1? Well, condition 1 is stated to be that the main purpose, or one of the main purposes of the arrangements, is that a person might reasonably be expected to obtain an advantage in relation to inheritance tax. Quite important to focus on the word advantage here. If something is inheritance tax effective by virtue of law, and certainly, of course, by virtue of legislation as well as case law, then I really don't believe that can be seen as securing a tax advantage. So, for example, if you access business property relief through investment in certain shares, that's given by statute, and as long as you satisfy the conditions of that statute, that can't count as a tax advantage in my view. I'm sure certainty will be secured on that, but I have no real fears on that at this point. Condition 2, remember you have to, as well as condition 1, satisfy either condition 2 or condition 3, and it's really important to remember that if you don't satisfy condition 1, then you can forget about condition 2 or 3. So basically, statutory relief's not a problem. That was indicated in the prior consultation. So condition 2, one alternative, is that one or more elements of the arrangement, note plural arrangements, would be unlikely to have been entered into but for the obtaining of a tax advantage. So tax advantage is the only reference, the only reason for entering into the arrangement. And then the alternative test, condition 3, is that the arrangements involved one or more contrived or abnormal steps without which the tax advantage could not be obtained. So again, more than one step, steps plural. So I think we have a reasonably clear indication that we're looking at contrived arrangements, steps inserted with a tax avoidance purpose only and no other legitimate commercial purpose. We also have some specific exclusions. And they basically are to do with the financial services sector, because excluded, it seems, are loan trusts founded on any kind of investment, bonds or collectives, and insurance-based discounted gift trusts, although we could do with a little more clarity and certainty around the description used for discounted gift trusts. Now, I have no doubt that the certainty and clarity that we are seeking will be forthcoming, I hope. I have no doubt, I hope. Forthcoming following the responses that will inevitably be made up to September by the sector. And hopefully we will get the certainty that we require. But the fact that they've included provisions specifically excluding loan trusts and DGT would indicate that they feel that the retail market use of trust-based arrangements is generally not seen as particularly aggressive, certainly those schemes that are currently in use. So more certainty required. As drafted, at first sight, seems a little too wide, wider than we would like, these draft regulations, but hopefully through the responses that were made and then the final regulations, we will get the certainty that we desire. Again, bulletins on this in Techlink, and we will of course be following the responses and the next issue of draft regulations very, very carefully.